facts about the case because it's been distorted in an attempt to sort of make it seem like a very radical, extreme case, which it really is not. It really is about fundamental rule of law issues. But the case does not claim that the government could never use lethal force against an individual who may threaten the United States. It really is saying that in this circumstance, in Yemen, a country with which the United States is not at war, the U.S. Constitution applies. And under that standard, if you're going to kill someone, you can only use lethal force in self-defense. And there are constitutional requirements for when you can use lethal force. A person has to present an imminent threat, concrete threat of deadly harm, and lethal force. Killing has to be, because killing is an extreme measure, has to be a last resort. That is not a novel proposition. That's not an extreme position. It is the law that governs every law enforcement officer in this country, and law enforcement activities that have involved and addressed national security threats. But the government is really trying to paint this case as a completely extreme fringe case that would threaten the national security of this country. But again, that really just gets at very basic constitutional and sort of rule of law issues. So I just wanted to sort of be clear about what the position in the case is, so that our allies can respond to some of the attacks on the case. But separate from the legal issues, which are sort of separate from the public advocacy messages we're trying to bring into the case, but separate from the legal issues and the merits of the case, what we are trying to establish right now is again, just the very basic goal of trying to get a court to actually review the case, to actually address it. And the government's response to our case, we filed in August of 2010, and in responding to our case, the Department of Justice under Obama did not respond to any of the merits. They didn't come forward and say, this is why we think we can do this. They came forward with technical defenses that go to three things. One is that the particular person who is bringing the case, which is the father of Anwar Al-Aulaqi, who is bringing the case because his son is in hiding under threat of death and cannot access the court himself, that he cannot act for his son because we haven't proven that his son couldn't bring the case himself. Two, and this is probably the scarier and more extreme position, that the case presents political questions. And political question is sort of a doctrine in the law that basically says that if a case involves national security and military affairs, that those issues are in the exclusive realm of the executive branch, and that the courts should have no business basically interfering. So the case should be dismissed on that ground as well. And third, even if our client, the father of Anwar, had standing to bring the case, and even if the case did not present political questions and could proceed, the government would have to, if the case did proceed, disclose sensitive state secrets that could threaten national security and that it should not be required to disclose. So the government's presented three grounds, or had presented three separate grounds for the judge to kick the case out of court, none of which went to its targeted killing policy or its legal justification for asserting this authority to be able to carry out war in a country in which it is not at war with, and to kill a U.S. citizen without any kind of process. And the judge unfortunately agreed. So the decision came out just a few days ago, and I can't believe that it was just this week because it's been a really long week. But the judge agreed, and that is sort of where we are now, is just trying to get the case reviewed in court. The court itself acknowledged that no court has ever, on political question grounds at least, refused to hear a case brought by or involving a U.S. citizen claiming a violation of his personal constitutional rights because of action by his own government, that this has never been done before. The judge actually said, I find it, quote, unsettling that my decision would mean no review of the executive branch's claimed authority to target and kill a U.S. citizen based on its own allegations. But nonetheless, he dismissed the case. And until the ruling is challenged, if it stands, what it basically means is that the government has unreviewable authority to target and kill any U.S. citizen anywhere on the government's own say-so. And the last point I just want to make, that's what the case is about, but all of this is being done, obviously, in the name of national security. If anything, some of what we've learned since 9/11 are that mistakes have been made. And part of what I've done at CCR for the past few years is work on cases of men detained at Guantanamo. And the government made these very same arguments about threats of national security, dangerous terrorists, who are going to, threaten the national security of this country. All of these reasons why courts shouldn't get involved, and the American public should agree and understand why the secrecy was necessary, and why denying the nearly 800 men detained at Guantanamo, why they should be denied any rights. And as we know now, just only after years of litigation, and the men being released themselves, now that we finally know some stories, and also thanks to whistleblowers who've come out from within the military and the CIA and other parts of the government, we now know that the majority of the men were innocent, were never on any battlefield, were never involved in any wrongdoing, but were detained without charge for years and devastated, they and their communities and their families. And we know this, one of the whistleblowers is, again, things like this have gotten far less attention than things like the government's periodic recidivism reports that surface every once in a while that talk about people returning to the battlefield. But alongside those kinds of reports, you have other things like a former senior State Department official who served in the Bush administration by the name of Colonel Lawrence Wilkerson, who recently filed a declaration in a court case on behalf of a former detainee who's challenging his detention and torture at Guantanamo. And this person sat in government briefings every morning from 2002 to 2005 in the Bush administration and filed a declaration in federal court saying the administration knew that the majority of the men at Guantanamo were innocent, but did not feel that it was politically feasible to release them because they didn't know how it would explain their releases to the American public, and that it would reveal that the detention efforts at Guantanamo were the incredibly confused operation that they were. So I would encourage you, this declaration is up on the internet, and I would encourage people to go to that and sort of use that in our advocacy to talk about this targeted killing case as well, because one of the reasons the government has reacted so strongly is to say that we are doing this in the name of national security, but that just cannot stand in the face of the experience of Guantanamo, at least, and the lies we know have been covered up, but we have tools that we can use and that we should use in our advocacy. So I think those are just the comments I wanted to make about the case. If you want to know more about it, I would encourage you to visit CCR's website. We have a web page on the case. The website is ccrjustice.org, and we have some action alerts about what you can do in terms of writing letters to your representatives, and just getting more attention on the case and the facts of the case, so that the government can't succeed in sort of clouding what the core issues are really about, with its inflammatory sort of rhetoric about the particular person involved, and national security threats. So thank you, and I look forward to our question and answer period.
Thank you, Pardiss. My friend Alicia and I brought this, our victims wall with us. This is just a few of the names of the men that we believe were preemptively prosecuted. Project Salam grew out of the 2006 prosecution of an imam in Albany, Yassin Arif, on terrorism-related charges. The evidence at trial indicated that Yassin Arif was intentionally framed by the government in a sting operation for a crime that he did not commit. On March 8, 2007, after Yassin Arif was sentenced to 15 years in jail, the prosecution held a press conference to try to convince the media, which had been very critical of the lack of evidence in the case, that the government had a basis to proceed against Mr. Arif. When a reporter asked if the government believed that Mr. Arif was actually a terrorist, the prosecutor made this response, and I quote the prosecutor, quote, Did he actually himself engage in terrorist acts? Well, we didn't have any evidence of that, but he had the ideology. Our investigation was concerned with what he was going to do here in order to preempt anything else we decided. So in order to prevent anything else, we decided to take the steps that we did. The prosecutor explained that their concern was with people who might not be interested in terrorist activities, but who might be sympathetic to the ideology and might help if a real terrorist happened to come along. This startling statement from the prosecutor in the Aref case confirmed what we have come to understand from hundreds of other cases. The U.S. government targets Muslims whose ideology suggests sympathy to terrorism to be prosecuted for faked or contrived crimes in order to preempt them from possibly supporting criminal activity in the future. Project Salam was formed to document this abuse of law and to advocate for the end of these prosecutions. Preemptive prosecution essentially has four components. Number one, the creation of ideological or thought crimes. That comes from the material support statutes. Targeting and profiling. Manufacturing of facts to create contrived or faked ideological crimes. And lastly, persuading a jury to convict based on contrived or faked crimes. First, creating ideological or thought crimes. Material support for terrorism laws provide the legal framework for criminalizing ideology or thought. These laws prohibit essentially any support in the form of money, services, personnel, or other support to any organization which the government has designated a, quote, foreign terrorist organization. How an organization gets on or off this list is an interesting question, but I'm not going to talk about that tonight. The problem of material support is more complicated than most Americans suppose because of the word terror. The government tries to create the impression that a terrorist organization does nothing except run around causing terror for no particular reason. In fact, all designated terrorist organizations have legitimate goals and aspirations. It's just that sometimes on occasions they have taken possibly inappropriate violent ways of achieving their objectives. The terrorist, quote, terrorist organizations may have programs to feed the poor, heal disease, bring justice and peace, protect themselves from genocide, and other such things. But if they have a paramilitary wing that uses violence to achieve their ends, they may end up on the terrorist list. In the Humanitarian Law Project case, various humanitarian organizations wanted to provide services, training, and advocacy to terrorist organizations to support the legitimate, legal, non-terrorist functions of the terrorist organizations to help them reduce or eliminate the need to engage in terrorist acts. The humanitarian law organizations argued that the material support laws should not apply to individuals like them who have no intent to support terror and are in fact trying to reduce it. The Supreme Court answered that the statute was written by Congress to prohibit all forms of support, wherever the motive, and that the court had to consider the statute as it was written. This is important because through our legislative efforts, we could change the way the statute is written to require that it be illegal, that material support must intend to advance the goals of the terrorist parts of the organization. The humanitarian organizations claimed that material support laws made it illegal to provide such services, training, advocacy for legitimate purposes. I'm just going to talk a little bit about what the Supreme Court decided in Humanitarian Law Project versus Eric Holder last summer. On the free speech issue, the court defined the basic question in this way. May a humanitarian organization provide material support to a designated foreign terrorist organization in the form of speech that supports legitimate non-terrorist activities? And the answer to that question was, the court said, free speech supporting terrorist organizations, quote, also lends legitimacy to a foreign terrorist groups, legitimacy that makes it easier for the groups to persist, to recruit members and to raise funds, all which would facilitate more terrorist acts. The statute tries to delegitimize terrorist groups by criminalizing any positive support given to them, even by free speech directed at non-terrorist activities. As an example of how this may play out in real life, suppose a Muslim became concerned about genocide about Muslims in Bosnia. He tried to join a jihadist training camp run by a designated terrorist organization in Bosnia to help protect Islamic communities there. But he was turned away at the border, went home discouraged, and did nothing more. The Muslim will have nonetheless committed a crime in the eyes of the US government. Even though everything the Muslim did was legal in traveling to and from Bosnia, his intent on joining a training camp conferred a tiny bit of legitimacy on the terrorist organization, and thus constituted material support for terrorism. A couple cases like that would be the case of Beyten Kaziu or Ziad Yagi and many other similar cases. So that is if a Muslim had gone to Bosnia to try to join an organization to protect the Muslims in Bosnia. But if a Serbian went to join a Serbian militia in Bosnia to terrorize the Muslim civilians, it is doubtful the government would have even noticed, because the Serbian militia is not a designated terrorist organization list. More recently, in use of these material support for terrorism laws, the FBI has begun to move against peace activists. And while the peace activists are not engaged in terror, their support for the non-terrorist activities of a foreign terrorist organization may, in the government's eyes, have conferred legitimacy on the organization and thus constitute material support for terrorists. Item number 2, targeting or profiling. In triggering preemptive prosecution, I believe that the government focuses on persons advocating, number 1, the ideology of jihad as defined by the government, or 2, activity or words legitimizing or sympathizing with the nonviolent goals of a designated terrorist organization as an indication of possible future criminal activity. Now, in the old days, when we used to have a constitution, the government would have needed probable cause before searching for evidence of criminal activity. In the context of the so-called war on terror, the government, or the FBI, does not apparently need probable cause anymore to investigate Muslims. The FBI engages in massive, illegal electronic surveillance of Muslims, and probably others as well. They receive huge amount of information through a version of the Total Information Awareness System that has been put in place, even though Congress earlier rejected it as being unconstitutional. They pressure other Muslims into giving them information, much of which may be false. And of course, the government sends agents into mosques. The mosques are bugged, phones are tapped, and even private attorney-client conferences are monitored. The FBI has a great deal of information to which decide which Muslims to target. Unfortunately, they only have the limited ability to assess the significance of this information, so their decisions about who to target is often wrong, both on the ideological basis and on the factual basis. But once a Muslim is targeted for preemptive prosecution, the issue is how to get a conviction, not whether it's justified. Now, the government also manufactures charges, and some Muslims targeted by the FBI provides enough basis for the FBI to claim that the target has violated the material support statutes by himself. The Holy Land Foundation, the Hashmi case, and many of those training camp cases are like this. But in other cases where there is doubt as to whether the target has sufficient terrorist ideology or has provided sufficient support to a terrorist organization, the government will then assign an agent provocateur to push the target into committing contrived crimes. At its worst form, in the cases like the Newburgh 4 case, this amounts to offering large amounts of money to bribed individuals with no interest or ability to engage in terrorism, to act like terrorists so the FBI can satisfy its quota of kills. In other situations, like many of the training camp cases, individuals who expressed a general interest in jihad but gave no specific support for any organization are pushed or enticed over the criminal line by the FBI agent provocateurs. In the Hyatt case in California, the Tariq Shah case here in New York are examples of this. In some cases, like the Hyatt and Shah cases, the agent provocateurs actually moved into their houses and lived with them for months, secretly taping everything they said and trying very hard to manipulate targets into committing crimes. Normally, entrapment would be a defense to such tactics, but the government has persuaded the courts to disregard this defense where there is a ready response by the target to the government's offer. This analysis is flawed, but unfortunately accepted by the courts. The ready response doctrine originally arose in inherently illegal situations. The government agent asked if the target wanted to buy drugs. If the target said sure, it was clear by the target's ready response that he was willing and able to engage in an illegal transaction and so was not entrapped. However, in our cases, the situation is completely different because the FBI agent provocateur typically starts with a legitimate offer like, because you are my dear brother in faith, I would like to loan you $5,000 interest-free. There's nothing illegal in such an offer. Why shouldn't the target take it readily? Only later will he learn that the $5,000 came from the sale of a missile to terrorists and is part of a money laundering transaction. His ready response in taking the apparently legitimate loan cannot be equated with an individual's ready response in accepting an illegal drug buy. However, there have been very, very few successful entrapment defenses in terrorism cases. The government also uses tactics to obtain convictions. Some of these improper techniques used by the government to secure convictions in preemptive prosecution cases. Number one, the government is notorious in not turning over exculpatory information or information which would show the defendant is innocent, maybe innocent. This normal tendency has been exasperated in terrorism cases because there's typically a lot of classified information from electronic surveillance which the government shows freely to the judge ex parte so the defense doesn't see it, to convince the judge that the government has caught a real terrorist, but may fail to make this evidence available to the defense. On July 10, 2009, the Inspector General of the Justice Department issued a report on the government's secret surveillance program, which stated in part that when the massive surveillance operation was commenced after September 11th, no provision was made for identifying exculpatory information. Information which suggested that a particular Muslim may have had ideological sympathies towards extremists, and so may be a security threat, could be selected from the secret surveillance, but information indicating the target did not have such ideological interests would not be identified. The unfairness of this is quite obvious. Since the government has an absolute legal obligation to disclose to the defense all exculpatory information in its possession, the Inspector General recommended that the government appoint a special prosecutor to review all the terrorism cases to determine if this required exculpatory or evidence that would show that the defendant was innocent had been disclosed and to dismiss those cases where injustices have occurred. Since preemptive prosecution cases are based on fake or contrived charges, it is likely that after such a review by a special prosecutor, most would be dismissed for failure to disclose exculpatory evidence. On April 5th, 2010, members of the City of Albany, New York City Council approved a resolution urging the federal government to adopt the recommendation of its own Inspector General and to provide for a special prosecutor to review the many terrorism cases to determine if the defendants were provided with the information as required by law. Unfortunately, so far, Congress has not acted on the Inspector General's recommendation. Project Salam has identified 5 different methods that the government uses to preemptively prosecute Muslims. The first one I'm going to talk about briefly is the agent provocateur cases, and we've probably heard a lot about that. The Newburgh 4 case is a perfect example, where the government sends in an informant to entrap people. These entrapments involved hundreds and hundreds and hundreds of hours of taping. The government in the Newburgh 4 case, for example, the agent provocateur drove the 4 defendants everywhere, bought them coffee, bought them groceries, paid for their rent, offered them $250,000, et cetera, et cetera. It's quite excessive. These cases take many, many, many months. And right now, we have about a case a week, I would say, right? We had one in Baltimore yesterday. We had one in Portland, Oregon last week. We had one in Washington in late October. They're coming so fast it's hard to count them. So there's the agent provocateur case that we're very familiar with. There are, however, 4 other different kinds of cases, and I'll be very brief. One is charity cases. And the charity cases involve an organization that may raise money for an organization overseas, such as the Holy Land Foundation case, which money was raised and given to the Zagat committees in Palestine. And even though the government agreed that not 1 penny of that money went to terrorism in Palestine, Geshan Alassi, who was one of the founders of the Holy Land Foundation, was given 67 years in prison. 67 years in prison. Other Holy Land Foundation cases are the Dr. Dafir case in Syracuse, New York. Dr. Dafir was an oncologist in Syracuse. He raised $1 million for Iraqi children during the sanctions. And he was put into prison because they couldn't get him on the, since there were no terrorist organizations in Iraq at that time, he was in prison for 22 years for making mistakes on his Medicare forms. The third type is the material support and guilt by association cases. And that would be, the case most famous in New York would be Fahad Hashmi. Fahad Hashmi was in London. A friend came to visit him. His friend had in his bag waterproof socks and ponchos, which Fahad probably didn't know about, who knows, at any rate. The friend left, taking the ponchos and socks with him. And at that point, he was arrested and put into, he's been in prison now, I think, at least 4 years. And he finally pled guilty because he didn't think he would get a fair trial, which, of course, I believe he was quite right. And sentenced to 15 years, Fahad Hashmi is now under special administrative measures in Florence, Colorado. Then there's the training camp cases. That would be the Lackawanna 6 or the Toronto 18. And these cases involve men going overseas, as I mentioned before, trying to join up with some kind of training camp or whatever. Now, America has a long history of Americans going overseas to fight for a just cause, like the, in Ireland or in Spain or other places like that. And we don't have a lack of white supremacists in the Midwest who use their Second Amendment rights, which is perfectly legal. But if they're Muslim, it's different. The last cases, I would say, are the other category, which would defy categorization, which would be the Dr. Afia Siddiqui case, Lynn Stewart case, and one case also from near Albany, the Imam Umar case. There are other issues that need to be addressed. One of the things is that when these cases happen, the defendants are held in very long pretrial detention under often very severe conditions. The Hashmi case and the Tariq Shah case are very good examples of this, where the conditions are so severe, it's impossible for them to mount a defense. Also, at trial, the government uses phony experts to parrot the government's theory of the case. Another issue in the case is the mistranslation of documents, which a lot of times these cases involve many foreign languages, and there's a lot of mistranslation. This happened in our Albany case. I think one of the interesting parts is the fake concern for security, that witnesses, the witnesses be allowed to testify anonymously, that when I went to White Plains for the Newburgh 4 case, when the day the trial was supposed to start, they had snipers on the roof, they had all kinds of security. But when the jury was not present, there was no security in sight. And that is kind of the show of theater that the government wants to explain that how dangerous these are. Thank you.
I'd like to give a bit of a more deconstructive kind of historic perspective and then move on to the legal developments, general overview to try to come up with actions. and it's good to have the information, but it should lead somewhere. So I'm hoping that we'll get to that portion of tonight's program as soon as possible. Lynne asked a very important question, where does this come from? And she answered it, I think, in part. But all of this long precedes 9/11, long precedes the Patriot Act, long precedes Bush and Cheney. And I don't want to go too far back, but the seeds of all of this, of course, go back to imperialism, but it didn't stop there. But then we saw in the literature from the birth of the United States, especially in the early 1900s to the mid-1900s, in particular with the establishment of the State of Israel, a new perspective based on a renewed and very strong interest in the Arab world, in the Muslim world more recently. So it's this, the implementation really of foreign policy by use of domestic laws. What's happened is they've been doing this for a very long time. It's only more public now because it's more widespread and people are able to act publicly and respond publicly. The media is more available. But this is not a new phenomenon. The other difference that I would say exists now is whereas today everybody's being lumped up into this socially constructed category of Islamist or Muslim, even though a lot of them tend to be Muslim, what they're targeted for is not that identity in and of itself, was preceded by the identity of Arab in the 70s. And that went hand in hand with attacks and attempts to repress the Arab nationalist movement, which was fighting for the end of imperialism in the Arab world, but specifically against Israel and Palestine. So this implementation of foreign policy by use and expansion of the material support laws, what you know as the terrorist laws, especially in the past 10 years, but it didn't start in the past 10 years, and we'll talk about that briefly. And it comes from the selective application. The federal courts have historically allowed for the selective application of repressive laws that have been on the books. The federal courts have said that the government has the right to implement foreign policy by attacking or repressing, targeting, selectively applying particular mechanisms against communities that come from the land that is, or the country or the nation that is having, with which it's having a foreign affairs crisis, if you will. So there's always been that permission, which essentially is a death knell these days we see to our constitutional rights and our civil liberties, because we're lumping people up, and suspicion is based on group suspicion. You have an overvaluing of the government's interest and an undervaluing of the individual interest. The history of Islamophobia, it's not post 9/11. Long before, we had tons of literature depicting the Arab, depicting the Muslim as a vile, slovenly, fat, obese, violent man, and as the Arab or Muslim female as either scantily clad or servile or otherwise docile. And it's not just in the literature. We grew up with these images. So this has all been ingrained in a really integral part of our consciousness in the United States, and it's been perpetuated quite intentionally. In fact, over the past few years, these films have always been in play, but the Department of Defense actually collaborates with Hollywood in the production of some of the films. I don't remember the name of one in particular, but there was one that came, that was released, I think, immediately after the Iraq War, or right before the Iraq War. And in the end of the film, an American soldier turns around, he's about to leave Yemen, turns around and shoots dead about 10 Yemenis. And across the United States, this received a standing ovation in movie theaters. And this was done in collaboration with the Department of Defense. So it's not coincidental. The language of we're going to war with Iraq or Afghanistan, even we're talking about the Gulf War, for democracy has strong implications that really permeate throughout society, because the implication goes two ways. Number one, that the Arabs or the Muslims are too stupid, too docile to know how to do this for themselves, or to want to do this for themselves, to be able to seek democracy in their own countries, or they are otherwise too violent and too repressive by nature to allow democracy to flourish. So you've got the government speaking, the media speaking, and this is all permeating throughout society, and so it's this really twisted cycle. And when we say society, we're talking about the judges, we're talking about the jurors, we're talking about the prosecutors that are trying these cases. So when you go into a courtroom handling a case where most of the language, as Lynne has suggested, is in Arabic, it's not just the person that's on trial. Their history is on trial. Their identity is on trial. Their language is on trial. And they bring interpreters from a very particular school of thought, because language is also politicized, to present a very particular and prosecution-friendly translation. So, and we've seen it in Congress, and not just in Congress, but in state representatives, the normalization of racist, really viscerally racist rhetoric. Going back to the 80s, the mayor of Michigan said that the damn Arabs were to blame for the economic failures or problems that Michigan was having. You had another congressperson saying that anybody wearing a diaper on his head should be stopped and questioned immediately. The open discussion about how to torture Arabs and Muslims has also contributed to the racist atmosphere that people are increasingly becoming victims to, but have been victims to for quite a while. So the Patriot Act was preceded by many other laws and policies and court precedents dating back to the 70s, but in 1996 in particular, the Anti-Terrorism and Effective Death Penalty Act was a real devastation to our civil liberties and constitutional rights. It expanded exponentially the definition of terrorism and really brings us to the International Humanitarian Law Project versus Holder case that we had in the summer, and included now we have coordination, but included likely to or will in the definition support or endorse terrorist organizations. You also had, and this was under the Clinton administration, so if anybody thinks this is a product of the Republican administration, that's not the case by any means. That's also when the mechanisms for using secret evidence to detain and to imprison and in federal trials was codified. So 1996, by the way, the AEDPA is the acronym, was in response, ironically enough, to the Oklahoma City bombings, which were conducted by a white former US soldier in Oklahoma, of course. And the provisions that came out have so far, to our knowledge, and it's not been proven otherwise, been used almost strictly against Arabs or Muslims, but not all Arabs or Muslims. There's constantly been also throughout, if not in the law itself, in the application of the law, exclusive classification and treatment, exclusive treatment based on nationality. So looking at the 70s and going back, I'm going to talk about the issue of Palestine and how it's been used, manipulated, and the impact on the Palestinian community in the US. And in 1977, or was it 72, I don't recall, during the Iran hostage crisis, which was a political act, according to the hostage takers at least, in support of the Palestinian liberation movement. So Nixon had ordered a clampdown by FBI and by INS at the time, what was called INS at the time, against all activists who were working around Palestine. In 1977 there was a waiver that was given to various immigrants that allowed them to adjust their status in cases where they would otherwise not be able to adjust their status. 2 years later, that was revoked for anybody who endorsed via speech the PLO and for Palestinians. So in '79 as well, around the same time where the PLO was quite active and there was an active movement to shut it down, many Palestinians were deported. Abdin Jabara was under attack, came under attack at the time. So Palestinians have been long subject to this, and Arabs have been long subject to this on the grounds of foreign policy vis-a-vis Israel. And in a lot of the cases, the entrapment cases that involved Arabs who were being imprisoned, and this also predates 9/11, Palestine was the carrot or the anchor really at the end of the case, in that the CI, the confidential informant, usually contacted the victim or the target and began shortly thereafter began having discussions about Palestine to gauge their political sentiment on the issue, and then any response or conversation used in that context was used to establish predisposition, which Lynn also earlier alluded to. I don't remember what you called it, but predisposition is what's necessary to get the final conviction when you have a thought crime. If your defense is, I was entrapped, the government's answer, the government has to prove that no, you weren't entrapped, you were predisposed. And talk around Palestine has been the ultimate evidence to that predisposition to violence, which leads to the conviction. So speech around Palestine has been criminalized in the courtroom and therefore criminalized in society at large, of course. If you compare looking at the Sami al-Arian case, for example, Sami al-Arian was tapped for about 20, his phone line was tapped for about 23 years. They had about 20-something years of recordings against him. This is long before. I know plenty of people, including family members, who within a year or two of entering the United States were being tapped and monitored, friends. Very commonplace. Many Palestinians were subject to these restrictions and violations long before 9/11. And the irony of it is, or not the irony, but perhaps one of the most devastating parts of this is that you realize that there is not just selective application, not just discrimination, but grossly unequal protection of Palestinians and Arabs and Muslims, but historically Palestinians and those who support the Palestinians struggling in the United States. The JDL, if folks are familiar with the Jewish Defense League, which was a designated FTO, in 1980 alone undertook 20 terrorist acts within U.S. borders. The ADL, which is an offshoot of that, was found to have compiled a database on thousands of organizations, most of which were neither Arab nor Muslim, illegally, like the Asian Law Caucus, the National Lawyers Guild. I don't remember all of the organizations. And instead, including Arab and Palestinian society community members and organizers. And instead of seeing any prosecution or investigation of the ADL, what the communities witnessed was investigation by the FBI of people who were found to be in that illegally made database of the ADL, including Palestinians who were imprisoned in Palestine by Israeli occupation forces. So, and of course, in New York, and we see throughout the US, you see the Jewish National Fund and other organizations giving wholesale, selling Palestinian land in contravention of international law without any prosecution, any investigation whatsoever. And on the other hand, you see Palestinians, as we've seen in Chicago, children, members of Students for Justice in Palestine, being issued subpoenas and having their homes raided for having organized events around Palestine. So there is a clear lack of equal protection for Arabs, in particular around the issue of Palestine, and Palestine has been manipulated. Lately, with the rise of the response to, I know this coalition was in response to what's perceived as this new wave of Islamophobia. What's been most unfortunate is that those who are the victims of this really vile racist rhetoric and the actual physical attacks, be it to their property or to their person, are the ones also now being investigated by the FBI en masse in New York, in New Jersey, across the United States, in fact. We are seeing now state repression against Arabs, against Muslims, that we have not seen in the history of the immigration of the Arab and Muslim population in the United States. Across the US, there have been massive targeting. In New York and New Jersey in particular, going back to the role of Zionists and Zionist organizations and kind of flaring this up, at a time where we were barely able to keep up with FBI investigations of community activists, organizers, or those who are not really active but attend various mosques, it was revealed by the Washington Post that the Mossad was engaging in a lot of the FBI investigations in New York and New Jersey, posing as FBI agents, again, without retribution whatsoever, and essentially with government approval. Matthew Levitt, who is he's an infamous expert witness, quote unquote expert witness on terrorism, in particular Palestinian terrorism, who's been around the country and testified a lot of these cases that are up on that board, is an ardent pro-Israeli Zionist supporter who neither reads nor writes Arabic and yet is an expert on all of these Arabic and Palestinian terrorist organizations. I mean, so there's a lot of hypocrisy, to say the least. And I wanted to talk very briefly about the raids that happened. I don't know if, I'm assuming that most people are familiar with the raids that began September 24th of the homes. I think at the time it was approximately 14 anti-war activists. And this really goes back to how is this all relevant to us. The precedents that were set so far back as 1977, 72, after the 67 war, and in 2001, and what we're seeing happen with the raid, even if they are targeting a certain community, those precedents are applicable to all of us. And what we're seeing is really a circumscription of all of our rights in the United States, our constitutional rights. And very, very soon, before we realize it, and it's good to see a good turnout here tonight, all of us will become victim in one way or another. There was another, I'm sorry to go off on a tangent, there was another really critical case. And I'd like to say, first of all, the FBI does not need probable cause to investigate anybody. They do need probable cause to take that investigation to a particularly invasive level, but nobody here has the right to be free from investigation. It's all a matter of what type of investigation you have the right to be free from, to what extent. Over the course of the summer, there were, the Supreme Court had ruled that the government has the right to place a tracking device, even a recording device, on your vehicle so long as it's not located behind a fence. You know, so this is a very class-based kind of definition of who has the right to privacy or who has the right to be free from being tracked and traced. And it's upheld. There were people who have found tracking devices on the bottom of their vehicles. But going back to the Chicago raids on the morning of September 24th, about 5:30 in the morning, I think it was I lost track of the number, 12, 14, 15, whatever it was, homes of anti-war activists were raided. Subpoenas were issued, warrants were issued. The warrants and the subpoenas, while they referred to FARC in part, the focus was clearly on Palestinian activism and organizing, in particular Palestinian delegations. Apparently there had been a grand jury seated for I think about a year and a half at the time, if not longer. Most recently, so the subpoenas were issued, and those who were subpoenaed refused to testify before the grand jury. The subpoenas were then reissued a few weeks ago for 3 people, and more people have been subpoenaed since. But since the subpoenas have been reissued, the prosecutor can essentially make the application to hold those who are refusing to testify before the grand jury in contempt. What's really terrifying is that in the past week, the subpoenas have been issued to children, people 19, girls, Palestinian students aged 19 and 21, and another 2 today, I don't know their identities, who were involved with Students for Justice in Palestine. In fact, one of them was the founder of Students for Justice in Palestine at DePaul University. And so I'm bringing the issue of Palestine because it's played a really central role in a lot of these entrapment cases. It's been the test case for a lot of the preemptive prosecution long before 9/11. The Patriot Act, I don't know if a lot of people know this, but the Patriot Act also, I don't know if it was the Patriot Act or AEDPA of '96, I don't recall, gave the government the right to secretly detain without charge any immigrant, including a legal permanent resident, for national security reasons for a period of 7 days. It was in 1996. The longest held administrative detainees who were not brought up on any charges and were held secretly have historically been Palestinian. Mazen al-Najjar, who was a writer on some Palestine think tank, was held 3.5 years without charge in secret detention on the grounds of national security based on secret evidence, which was never presented to him and, of course, which he was never able to challenge. And the other one, who was held for approximately 3 years, was also a Palestinian. So the issue of Palestine and Palestinians really have been targeted and used, I hate to say that word, in many ways. And as we're moving forward and looking toward the foreign policy interests of the United States in the maintenance of the Israeli state, and also, in my opinion, and I could be wrong, in keeping the Palestinian Authority in power. And I think that that's why a lot of the attacks have increased against Palestinian organizers recently, so that there is no challenge to the undemocratically elected Palestinian Authority. I think it's really important that we take a deconstructive approach and we really start looking to the underlying laws, to the application of to the selective enforcement of a lot of these laws, and considering Palestine and the issue of Palestine and Palestinian organizers and how they're treated as really a seminal part to fighting and for the protection of our collective constitutional liberties.
If you can demonize an entire group of people, you can justify their bombing, you can justify their invasion, their occupation. They will therefore be seen always as enemies, even as they live amongst us, even as they our us. Through this demonization, the actual double standards of the U.S. government become glaringly focused. Human rights in the United States and the idea of human rights as exploited by the U.S. government is essentially used as a way to cover up our government's true motivations, true desires, and to kind of pull a veil over our actions overseas. I'll actually start by regaling you with some of the words from a statement issued today by our President Barack Obama in order to commemorate Human Rights Day. Part of what he said is that freedom, justice, and peace for the world must begin with basic security and liberty in the lives of individual human beings. A lovely thing to say. The U.S. just doesn't really care about that. You can look at the lives of Iraqis. You can look at the lives of Afghanis. You can look at the lives of Pakistanis and Yemenis or Yemenis and Palestinians, of course. These individual human beings apparently don't have these inalienable rights to basic security and to liberty and to life that are enshrined in the very Declaration of Human Rights that today is supposed to commemorate, which was signed by the UN General Assembly 62 years ago today. The president continued, from the freedom to associate or criticize to the protection from violence or unlawful detention, these inherent civil rights are a matter of both pragmatic and moral necessity. Now, this is coming from a president who has done more to stifle dissent than our previous president. This is coming from a president who has actually denied trials to more people than the previous president. 2 days ago, the House of Representatives passed a funding bill that contains within it a ban on using federal funds for criminal trials against Guantanamo detainees that would last until at least next September. So it's essentially saying whoever is in Guantanamo now won't be getting out anytime soon because they're not even allowed to be tried because there are no charges against them. And yet, again, as Obama said today, that the protection from unlawful detention is something that this government apparently really cares about. He also said that the United States will always speak for those who are voiceless, defend those who are oppressed, and bear witness to those who want nothing more than to exercise their universal human rights. Now, obviously, as long as they're not Palestinian, this would work. As long as they're not Iranian, this would work. An inalienable right as enshrined by the UN is the right to pursue nuclear power. Agree with that or disagree with that as you may. that is enshrined as an inalienable right. Apparently that is not covered under what Obama was obviously talking about. So why is this important? Why are Obama's words so in stark contrast with the actions of his own government and of our government? And what I think we see is that the double standard of the U.S. government, as I said, covers up the real motivations regarding our foreign policy, especially with reference to our actions in the Middle East. Namely the maintenance of military hegemony, of allegiance to Zionist mythology and nuclear supremacy, continued demonization and threatening of any country that dares to question this moral superiority of the United States or actively seeks to oppose American and Israeli imperialism within their own countries. We should remember that the Declaration of Human Rights was born out of Geneva Conventions, was born out of Nuremberg principles. And I wanted to point out that in July of 1946, Robert Jackson, who was the chief U.S. prosecutor at Nuremberg after World War II, stated in his closing argument of the trial of major war criminals before the International Military Tribunal. And what he said during this closing statement is that of all Nazi war crimes, including invasion, occupation, displacement, concentration and extermination camps, ethnic cleansing, and genocide, of all those war crimes, he said, quote, "The central crime in this pattern of crimes, the kingpin which holds them all together, is the plot for aggressive wars." A few months later, when the judgment of the tribunal came in, the judges maintained this idea, and within the judgment, they wrote, "To initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole." Now, when we're looking at human rights abuses, when we're looking at human rights abuses so egregious that they turn into war crimes and crimes against humanity, what we find is the chief violator of these rights and the chief perpetrator of these crimes is the government that talks about human rights more than any other, and how important those human rights are more than any other, and it's our own.